Welcome to You Can't Say That in Court, a podcast by Rise Women's Legal Center. I'm Vicky Law.
And I'm Stephanie Melnick. We are your hosts in this conversation about survivors of violence navigating the BC family law system. We recognize that this system is colonial and causes harm to families, and that disproportionately impacts Indigenous people.
By speaking more widely about these harms, we hope to raise awareness about the challenges that survivors face as they navigate the colonial family law system. This podcast is our attempt to collectively identify the barriers and ask for positive changes to be made. Thank you for joining us. Our podcast series will discuss difficult topics such as gender-based violence and intimate partner violence, including physical, sexual, emotional, psychological, and financial abuse. Please be aware that this is a thread that is woven throughout all the episodes, and we hope that you will take care of yourselves however you need. Welcome to another episode of You Can't Say That in Court. Today, we're very excited to have our first guest, Stephanie Hodgson, who is a lawyer on the so-called Vancouver Island and shares an office with Moira, the adopted Border Collie, Aussie Shepherd, Great Pyrenees Mountain Mutt. Welcome, Steph H.
Thank you, Vicky. I'm really, really happy to be here. And unfortunately, Moira is not in right now, but I can say she's very bad at filing, but she's very good at leaving dog hair on my court clothes. So, she has her
spreading love. She's
and
good
spreading
at
the love. And yes, the licks. I thank you for that introduction. I have been practicing family law and child protection, it's called. We call it family policing, representing parents and other guardians and family members on this island and over a bit on the Sunshine Coast and so-called Powell River for about a decade now. That's been my majority focus. And I've always been interested in the intersection of gender and sexuality in the law. And I'm very happy to be here. As I said, I'm a sole practitioner, but for the dog that comes in. And as a lot of folks know, I moved to Saskatchewan in 2007 to go to law school, and I got to meet Vicky in 2009. And we both find our way here, and very happy to be connected with another Steph through Rise as well. So thank you.
Yay.
I feel so lucky to have two Stephanies joining me today. Yes.
I was going to say, so it doesn't get confusing, I'm Steph M, and Steph Hodgson will be Steph H. That's how we're going to do this. Yeah.
I will be referring to each of you as Steph M and Steph H.
Perfect. Love it.
Let's get going. So we're talking more about gender-based violence today, specifically about how to listen to someone or how to detect when someone is disclosing violence. And we all think this is really important because it is more common than we know it to be, especially in the legal profession. And this is not something that's easy to figure out when we're talking to clients.
Yeah, I was going to say that's why we talk about it so much, I think, because it's hard to detect. It's hard for clients to understand what they have experienced or are experiencing and then name it, and then even further translate it into legal language, like we've talked about in the first two episodes about some of the terminology and referring to things as family violence and what does that entail, and then the added layer of coercive controlling behavior. So it gets complicated really quickly, for sure.
The work I do right now, I'm, as I said, parents counsel. I represent some aunties, some grandparents, some family friends who are involved in guardianship and the care of children that under the Family Law Act, under the child protection legislation. Also family duty counsel in a few courthouses. I'm also on the family law line. All of these are initiatives through Legal Aid BC. And the vast difference between understandings person to person of what family violence is in lived experience, but also what family violence is according to our family law legal system is huge. So I'm very happy to be a part of this conversation so we can dig a bit deeper into the bits and pieces of how to help folks and also the messaging that all lawyers can work on putting out there to their potential clients, their retained clients.
Yeah, let's talk a bit more about this vast difference that you're hearing that or that you're detecting. What first off, what is this difference that you see, Steph H?
Well, the a lot of people know when they're being mistreated, and they are not everyone, certainly. In a podcast setting, I mean, first of all, we have to clarify, of course, the podcast is not, this isn't legal advice. We're going to be speaking on very general terms, and which can gloss over a few things. But I think in this case, because we're not able to use specific examples, we do have to be general in terms of maintaining confidentiality and client experience, that sort of thing. Just so that's my disclaimer. But I get a lot of people I chat to and have as retained clients, they will express their feelings. They feel that they've been mistreated. They feel that things are not going the way they want them to. They feel that they need a change, and that's great. That's generally why people contact family law lawyers, is big changes are coming in their families or have already happened. They need to respond to them. But not a lot of people are sitting down and going, I've looked at the Family Law Act. I've seen the definition. I've looked at the definition of best interest of the child. I've looked at how family violence intersect with best interest. And I know that I'm being coerced. I know that I'm being controlled, or there's an attempt to control me that I don't like and I need to get away from. Um, so it's that, right, that lived experience versus academic experience is certainly a huge gap. But also folks, as you mentioned earlier, Vicki, also folks that come in and they describe experiences. And depending on what my role is, if I'm retained counsel and I know I'm going to have a longer relationship with a client, I know I have more time to build that relationship. I tend to be a bit gentler and just say, listen, like based on my knowledge and experience, what you're describing to me sounds like family violence. It sounds like it falls under the definition. Is that something that, have you ever thought about that? Is that something you want to talk about more now or maybe later? But in my role on the law line, I often talk to folks, or duty counsel, I'll talk to them once. And on law line, it's on the phone, so we can't see each other's faces. So there really is that removal of any, the phrase I want to use is ocular judgment, right? That like, why are you looking at me like that? I'm not looking at you at all. You're not looking at me. We can't see each other. You don't know what my face is doing. So I'm more likely to say things like, listen, what you're describing to me, that's family violence. Like I don't know if that's right. I don't know if that's a thing that works for you, but what I'm hearing and based on what you're sharing with me, the law, that's family violence. And I often get a lot of pushback. And, oh, no, couldn't possibly be. That's not my family. And then I will go down the list. I will literally go down the list of the definition and go like, it's not just physical assault. It's not just stalking and harassment. Coercive control exists. And when kids are involved, it doesn't have to be things that are directly happening to children. It can be things that are happening to parents. And then a child is living with a parent who is actively receiving violence on a regular basis. And kids are intuitive, right? Which flows into a discussion about how over the years there's a less paternalistic, there's a requirement now, truly a requirement, or you can, judges get their decisions appealed if they don't do a specific individual, what is it, individualized and discretionary best interest review for each family. So being able to say, listen, like social science evidence, folks are on board, judges are on board, counsel should be on board, that children are intuitive. Babies know when they live in a situation that's making them stressed. They can't talk about it, but they know. Little kids know. Little kids know when their parents, right? One parent is reacting to a situation that's not okay. And the courts have to take all that stuff into consideration. So it's right, this huge spectrum of folks that come in. I mean, I've had people come in and say, I've read this book and this article and this, I've read the Family Law Act and the CHOP, I've read it all. And folks who are ready to diagnose their family down to the letter. But that's not the majority of people. So it's that counsel also being required to do an individual and discretionary assessment of what's going on in the time available.
Yeah, I don't think as legal professionals we should expect clients to come to us and say, what I'm experiencing is under this in the Family Law Act, or I need this and that. Like, that's our job as lawyers, right? To detect and to listen, and to provide the legal remedy. There are legal remedies for family violence under the Family Law Act, and it is our jobs as lawyers to figure out what those remedies are and what is the best fit for clients experiencing violence.
Yeah, I like the approach that you're talking about, Steph H, with pointing at the definition. We talk about this a lot at Rise about we can use the definition as a tool to frame what the courts could potentially hear. And I'm curious, though, about the language or the terms that you might hear someone use to describe their situation that's not the legal definition. It's not, using those terms that are kind of translated so that the courts can understand what's going on. Do you have, a little bit of insight into that? Yeah.
Certainly. I hear, and this just as of yesterday, I'm thinking of a specific example, but I hear a lot of, but they said. Whoever whatever the situation is that I will say something along the lines of, there are remedies. And people oftentimes it's folks who like I said, they've done a bit of research and they're going, this is the thing I want to try. And certainly I know that in future episodes of the podcast, there'll be more discussion about like the specifics of practice. But, I want to try making an application for guardianship if they're not a guardian, or protection order, or et cetera, under the Family Law Act. Or they'll come and say they want a restraining order, which as practitioners, we all know there are no restraining orders in family law. Or I want to get them charged under the family legislation. It's like, well, that also isn't a thing, right? So that's the one piece. The other piece, though, is folks come and they go, all I know is that I can share this information. They're not saying that. They're not saying that. But essentially it's, I'm laying this information out to you as a lawyer. I figure that as a lawyer, you probably have some options for me. I have no idea what they are. So I hear a lot of, but so-and-so said that I can't do that. Or so-and-so said that if I do that, I'll get in trouble. And and that specific phrase, like they said, I'll get in trouble. And I take, not pleasure. It's right. It's not, it's not a pleasurable experience, but I do take some professional pride in being able to say, they're wrong. They're wrong. You're not going to if you get in trouble, it's because the judge that you are dealing with perhaps is having a bad day, or has, not been educated recently. Or if you've got an opposing counsel coming at you saying, well, if you withhold your children from my client, that's parental alienation and you're going to get in trouble. So I do take a little bit of professional joy in going, no, you're not gonna get in trouble. Especially not if you've got a lawyer representing you who's willing to back you. And I think that's where a lot of folks come up against pushback. They come up against communication difficulties because there is such a vast difference in education levels around family violence for lawyers who practice family law, child protection, family policing.
There are also a lot of perceptions, if you don't mind me jumping in for a second. There are all these like misconceptions, right? We've talked about this a little bit already too, that if someone has been threatened with not being able to see their kids anymore, they believe that that's really likely. And so that muddies the waters even further, right?
That exactly. That's the further down the road to difficulty for me as counsel is presenting the options and trying to build a relationship. It's early days, and of course we know that under the Family Law Act, there's that informal parenting time section, status quo, right? Most folks have heard the phrase status quo, right? You set a status quo, and then before it can be changed, if it goes before a judge has to assess has the child been living that way for a while and is changing it in their best interest. So getting on things quickly, right, when there's a separation between parents, guardians, right, when, say, a social worker comes into the picture, right, there have been, the big changes are happening. It's that thing of, okay, I struggle with the balance between making my client comfortable and feel comfortable enough to instruct me and to have the capacity to instruct me based on the advice that I give them and the options that I give them, versus that paralysis that I sometimes see in my clients where they go, I okay, thank you for the options. I'm going to think about it. And I'm checking back in, right? Not wanting to be a bother, but knowing that they've got so much else on their plate, not wanting to be a bother and going, like now would be the time, especially in a where there's no court orders in place
Right.
under family law.
That paralysis is like, we talk about it at Rise often too, right? Because for someone who has had their autonomy taken away from them during an abusive relationship, providing that choice to choose what to do next can be paralyzing. It's kind of like the fight freeze kind of mode, right? And it's I kind of see that in that freezing, but I want to take us back to the difference in education, because I don't think everyone knows this, which is that family lawyers don't have mandatory training in family violence. This is something that Rise has trying to push towards, and it is a goal of ours to make sure that everyone who does family law or family policing work gets training. And ongoing training, I think, is important. And I think the two of you would agree with me that it is not just a one and done situation, but we're all constantly learning.
Yeah, I do. I agree wholeheartedly. And I had the privilege of doing the last training that Rise put out as a continuing education project endeavor. And I mean, so folks know the law society of British Columbia says every lawyer has to do 12 hours of continuing education a year. And it's up to us to get it done every year. If we don't stay on the website that we've got it done, we have to do, of that, 2 hours has to be professional responsibility and ethics. And if we don't do it, they say you can't be a lawyer. And if we still don't do it, there are fines, recriminations, regrets, so forth. But if you don't tick the box, the Law Society can take away your ability to practice law, which is why we're here, as on a livelihood level. But of that 12 hours, you're totally right. There is literally no requirement to touch on family violence, which is truly too bad. And I agree, like, the work Rise is doing is very important. Getting it out there to more councils, very important. There are still, I am not, let's say I'm not a spring chicken, but I am very much, occasionally I practice with lawyers who have been lawyers since before I was born. And I am now practicing with lawyers who could be my children. They are that much younger than I am. So it's a 50, 60 year spread. And consider how family law has changed over the last even 40 years, right? The big updates to the Divorce Act in 1989, the Family Law Act in BC changed so much in 2013, and that's 12 years ago now. And things continue to change. So, and the social science evidence has the ability to bring it into court is getting easier and easier, but it's still not easy to get a judge to, like, without an expert report, to get a judge to just acknowledge, like, hey, these things are something. And as lawyers, we don't know what the judges are learning either. Right? That exactly. Like, we have an idea. We're kind of told, like, thematically what the judges learn, but we don't know exactly. So yeah, it's one of those things where we, just like with clients, we can't assume that a client has a certain amount of knowledge, but we also can't assume that the folks that we're working with have a certain understanding of family violence. And it's constantly assessing. That's really, like, our role in this, to be, the buzzword of the last few years, beginning of COVID, was trauma informed, right? To be trauma informed. The important thing, like, it's not just being trauma informed, it's trauma informed practice. So it's the P in TIP, the practice. We have to, if one as a lawyer wants to be trauma informed, we cannot assume experience or lack of experience, but we also can't assume knowledge or education. And that just makes our jobs I mean, there's no off switch when it comes to that sort of thing. You do, especially in an opposing counsel situation, in a situation where someone's going to be cross-examining my client, and my client's the basis for their position is life at home was violent. There was family violence in our family. And in order to move forward, Your Honor, we need orders that address that. Opposing counsel doing their job is going to come and attack my client's experience. So it's that being able to prepare a client, like being able to say, listen, I've worked with this person before, right? This person and I have done work together before. I know that they are educated, and I know that they are at their heart a kind person, right? As opposed to that person's a wild card. I can't prepare you, right? I can't prepare you for what's going to happen because I really don't know.
Well, it gets into an additional dimension of there's the education piece for lawyers who are practicing family law, and then there is the willingness to talk about family violence. And that is a whole spectrum of willingness as well. And it goes all the way from not interested at all in bringing it up or addressing it in a court setting or in any kind of proceedings, all the way to almost weaponizing the family violence and using it to discredit someone who is explaining their experience. It's such a wide range of ability, and it's almost familiarity with it. Education is a piece of it, but then also that comfort level, and how I guess there are some stereotypes and some preconceptions that come into it as well when lawyers are coming to family proceedings and how they're going to broach family violence. It creates a bit of a wild card situation, like you're saying.
It really does. And sometimes the answer to questions from clients, potential clients, duty counsel, law line, it's like, well, why can't it be that way? And the short answer is simply because it doesn't work that way. Right? That way. And that applies to counsel sometimes, because certainly the idea that if you bring family violence into a family law proceeding, that all of a sudden it changes the burden of proof, that it makes it the bar to prove something gets higher before the courts. And sometimes I get the feeling that maybe a little refresher about standards of proof, maybe being, family law is civil law. It's civil law. It's balance of probabilities. That's right. Like, we've got our scales of justice. Balance of probabilities tips the scale one way or the other. It just has to tip a little bit. That's the civil standard, as opposed to the criminal standard beyond a reasonable doubt, which is, unless, Your Honor's 99.9% sure, right? That person's gonna walk, or or Crown won't approve charges, or that sort of, right? That sort of an idea, and which is, not to delve into the family policing standard, which is often likelihood, right? Likelihood. Right. Social workers will go, well, so-and-so parent needs to do additional education or counseling around family violence because there was an allegation. And the response can often be, well, I was never charged and I was never convicted. I'm like, well, it doesn't matter. It doesn't matter. Social worker said. So unfortunately, this is where we find ourselves today, right? That's just the way it works in this case. But with counsel who, certainly I've had experiences where family violence was brought into the conversation, and opposing counsel have said, well, unless you have proof, then you have nothing. It's just like, well, that's not how family law works. Family law works on credibility. It works on, and not to say that criminal law doesn't, but right, there's that balance of probabilities, or credibility comes in more, and the ability to communicate, especially by the person alleging family violence, becomes such a huge factor, because it's not like in the criminal law system where you've got Crown, who are very eloquent, trained, experienced professionals putting forward claims, charges. We've got the person themselves, and especially, right, if they're taking the stand, less so if they're drafting an affidavit, but if they take the stand, it's that thing of, even if our client has what we would consider in family law an airtight case, right? How many of those are there, right? No, never any guarantees. But even if what they're telling me in a safe, right, if we've created together a safe, comforting environment, if they have their advocate, their support person who they've agreed can sit in on the meeting, can be their note taker, can literally hold their hand, right? With me, they're able to communicate in a smoother, more, we can encourage a more linear way, in a way that a judge would receive that's favorable to their case, versus have fun sitting in the witness box that you've never sat in before. You'll be closer to the clerk, you'll be closer to the judge than you are to me. And opposing counsel is going to be cross-examining you, and they're going to be between us a lot of the time, right? The only face you're going to see in front of yours is this person who wants to discredit you. Even though I've been sitting there going, I hear what you're saying. I hear what you're saying. I am receiving what you were saying. And you don't have to. That's the beauty of duty counsel and of law line is I get to tell people, I'm on your side. I put your name in my conflict list. I've put all the opposing parties in my conflict list. They can never call me. I am on team you forever as a lawyer, right? You can come back in 20 years. And when I go, as presuming Excel still works and my backups still work in 20 years, right? I will put your name, right? Date of birth into my system. When you pop up, I will go, yeah, I can talk to you. I can't talk to any of those other people, but you, right? I'm on team you. And so I get to say to people, you know what? We have limited time, which is a bit of a disadvantage, but you don't have to prove anything to me. You're telling me what your experience is and you want to know what your next steps are. Great. I'm on team you, right? I often won't use I won't say I believe you, because I don't think that's that education piece and that like differing colleagues piece. I don't think it matters if we believe the clients. I know a lot of them want to feel believed. I think we can do that without saying the words.
I also feel like the phrase has gotten a bit trite.
Right?
So,
yeah. It's I believe you. It's like, does it matter legally speaking? No, it doesn't. But I want to support you. I support you, right? I'm on your team. I support you.
I think the important is telling clients, like, you don't need to convince me. Like, I don't need you to convince me. I am here to like give you the options, which is very different in court. And Steph H, you said a line that like boggles my mind when counsel we work with say, where's the proof in the family violence? Where is the proof? And I was like, well, the proof is that there's this person telling me it's written in an affidavit. An affidavit is evidence, or the person will, take the stand and give viva voce live evidence and it's up for the judge to determine credibility, right? That's where the proof is. It's not like we need a third party witness who saw everything or a recording of violence happening or that, right? Like the people's own account of what they've experienced can count as proof in the legal system.
Exactly. And I'm very happy that you brought up recordings, because more and more, it's 2025. We live in a world, we've all got our phones in our pockets, right? Or in our bags. And the instinct to get a phone out and record a thing has just, on a human level, has become so much stronger with social media, etc. And I always tell folks when they say, well, I've got a recording that you have to see, or I have a recording that you have to hear, I always tell people, listen, that might be evidence for us in the future to use, maybe. So hang on to it, make sure it's backed up. But as of this moment, it's that, and I hate shutting people down because they feel like they have the case cracker. Well, I got this recording. It's going to be great. And then sometimes, I've stopped generally doing this, but in early days when I would listen to the recordings, it would be like, this is nothing. This is nothing. A judge will not think this is anything. And also, did the person you were recording know you were recording them? No. Okay, this is probably nothing. However, the flip side of that coin is now we've got, I have people come to me and say, well, I'm really scared to bring that thing up because of the way I reacted to it. And they've got a recording of me reacting. It's more and more common with folks that I talk to, where they feel first of all ashamed that they've lived in this situation for any length of time, but then shame that they reacted in what I would consider a psychologically appropriate way. They've been poked enough times, and then right when they're about to go over the tipping point, this person who knows them better than just about anyone in the world pulls out a recording device and goes,
Mm.
what are you going to do now?
Yeah,
And
it's
the choice is
very
either,
calculated.
right? The
Yeah.
choice is either nothing or the roller coaster's already gone over the hill and I'm no longer, right? This argument is now having me. I'm not having
Mhm.
it. Um, and so being able to tell folks, listen, like it's not as great to tell them that what they think that their case cracker is maybe nothing, but being able to say, listen, that thing that you're describing to me, okay, it's not literally nothing, but with the experience I now have of sitting in trials and having opposing parties present recordings to judges and having the judges scrutinize very specifically and then in their decisions, either written or spoken, saying, this recording was presented to me and here are the reasons why I do not put stock in it, right? There's that piece of, listen, like just because it exists, both sides of the same coin, just because evidence exists doesn't mean it's relevant, doesn't mean it's credible, doesn't mean it's
Well,
going to be admissible.
Or
yeah,
should
it
be given
also
any weight.
or should be given weight, or it's missing context. And when we talk about coercive and controlling behavior, I've said the piece I love about it is that it's a pattern over time. And so having just a snippet of something that happened, again, you're right, it's not nothing, but it's missing that context. And that's where the person who's experienced the course of controlling behavior or whatever it is, they can give so much more compelling evidence because they can explain over time a whole series of things that have happened. And I think the courts would hear that a lot better, or at least that's what we're hoping. And that's kind of the point of the podcast too, is to get that out there.
Yeah. And I'm so, thank you, Steph. I'm so glad you brought that up, the pattern. That's where the evidence is most helpful for counsel, folks. If I may speak to the people, that's where the evidence is most helpful. And I tell people, back up your texts. And they go, oh, well, they're saved on my phone. I go, I don't care. Back it up somewhere else, right?
Yeah.
Back up your emails. You've got texts, send them to your Gmail. You've got email, send them to the cloud. You've got the cloud, change all your passwords, right?
Mm-hmm.
All of these things. Make sure that your backup, and you know what? Go old school analog. You have a computer printer. I'll tell you how to put your text snapshots, your screenshots in order so that there's context built in, right?
Mm-hmm.
The brief, the brief primer is you want every message to begin with the end of the last message or the end of the last screenshot, right? You want to, and if
Right.
make sure there's a date, go back up to where the date is listed, doing those things and impressing upon people that, listen, it's not that one horrible thing happened, right? Like, and of course, sometimes that one horrible thing
Yeah,
is the thing
it
that
could
makes
be.
folks go,
Yeah.
it's the only thing that's ever happened, but we're done. I'm out. I'm taking the kids. I'm gone. That sort of thing. And then they're chatting with me. But it's more one of the big tipping points or indicators for me is when clients say, I didn't really think that was a big deal, Bo. I didn't really think that was a big deal. And then
Mm-hmm.
sort of going down the timeline and going, okay, so what, you guys had a temporary separation. What happened in 2022? Oh,
Mm-hmm.
this thing happened. And then, we broke up I went and stayed with my mom with the kids for a few months, but then, they were being nice to me again. So I went home. I went, oh, that thing that happened, that was a big enough thing to make you leave for a couple months. Yeah. But I didn't think it was a very big deal. I was going, okay. So do you keep a journal? Do you have notes on your phone? Do you keep a calendar? Right? Were you ever harmed physically? And I know we speak now about how the definition of family violence is so expanded that it's generally not physical violence. It's not
Mm-hmm.
leaving bruises or breaking bones. But did you go to a clinic? Did you go to a hospital? Right? Is there another record that we can use that shows the pattern? And I mean, flip side of that coin, I get folks who come in and say, well, in our relationship, there's never been any police involvement and I've never been charged. And they go, and that should be enough, right? That should be enough that a judge is not going to consider family violence in our relationship. I'm going, no, there's so much more to it than that. But
Mm-hmm.
if you can add no police charges, no police involvement, no social worker involvement, plus we are, I don't know, it's that thing of right, we can't ask folks to prove a negative, but questions like, will the other parent be able to provide a pattern of hospital, doctor visits? Will the other parent be able to do, were they in a, will they be, are you aware if the other parent, when they left you for a period of time, did they ever go to a shelter, to a transition house? Did they ever go to stay with family or friends on an emergency basis? Those pieces, right? Even though there were no charges and no convictions, did they make police reports? Right. And then as counsel, like I represent all parents, all guardians that come to me through, generally through a legal aid referral. And so it's that piece of, okay, the backwards way of trying to figure out, how much of a conversation about family violence should we be having here? And as counsel, building evidence in support of my client, on the one hand, of course, it's sad and it's troubling when you have a parent who may be the aggressor and is going, but that wasn't a big deal because I wasn't charged, I wasn't convicted. But then being able to say, listen, like, here's this group. Here's a group specific for dealing with maybe a family who maybe has had these experiences. And I would be fibbing if I said I never gave legal advice. Like, actually, I was going to put it in air quotes. It's not air quote worthy. I have given legal advice that has been support your family advice. Legal advice that has been go and get yourself supported, go and get your own issues addressed so that your family is supported. And yes, there is the aspect of it supporting your family law case, but also it's not just you. Like, if you meaningfully engage, and that's the thing, right? Meaningful engagement. If you meaningfully engage in these programs, not only are you going to be able to tell a judge you did them, but you will get the benefit of them.
Yeah, I like all these questions you're bringing up that you would talk to your clients about. It kind of gets us into the next topic, which I think is going to be talking about screening and what lawyers do. To detect, and then it gets into strategy a little bit.
I just want to say thank you so much, Steph H, for joining us. It sounds like this is your first time, but definitely not the last time you'll be on this podcast. So really appreciate your time and all the knowledge that you have shared with us.
Yeah, that was really great. I love going down rabbit holes, and that was a whole bunch of rabbit holes. That was fun.
Indeed.
Fabulous.
Thank you.
Yes.
Thank you both very much. And I am so honored to be a part of the podcast, and I'm sure that it will be very successful and long running. And yes, I'm very happy to return. Thank you both.
Great.
Thank you.
Everything that we have said today is not legal advice. If you or someone you know needs legal advice, please consult with a lawyer. We want to acknowledge that this podcast would not be possible without the generous contribution by Women and Gender Equality Canada, Femmes et Égalité des Genres Canada.